You're listening to KSG Podcast. This is a short, crisp, concise, exam oriented, edited editorial for civil services aspirants. The topic for this podcast is First Amendment to Constitution Challenged. Source for the content is Apurva Vishwanath's article for the Indian Express. The Supreme Court recently agreed to examine a plea challenging the expansion of restrictions to the fundamental right to freedom of speech and expression that was made by the First Amendment to the Constitution. The petitioner, who has challenged the law nearly 7 decades after it came into force, argued that the amendment damages the basic structure doctrine. Now, what was the First Amendment to the Constitution? Just over a year into the working of the Constitution, then Prime Minister Jawaharlal Nehru introduced a bill to amend the Constitution. On 18th of May 1951, the amendment bill was referred to a select committee which considered the issue for 6 days. The amendment officially came into effect on the 18th of June 1951. The Constitution First Amendment Bill sought to make several consequential changes, from exempting land reforms from scrutiny to providing protections for backward classes in the Constitution. Notably, it also expanded on the scope of the restrictions on the right to free speech. So, what exactly is the constitutional position on free speech? Article 19(1)(a) in Part 3 of the Constitution guarantees the fundamental right to freedom of speech and expression. But this freedom is not absolute or unfettered. It is followed by Article 19(2), which lists exceptions or reasonable restrictions on that right. The text of Article 19(2) in the original Constitution read, "Nothing in subclause A of Clause 1 shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to libel, slander, defamation, contempt of court, or any matter which offends against decency or morality, or which undermines the security of or tends to overthrow the state." Following the amendment, Article 19(2) was changed to read as follows: "Nothing in subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense." Thus, the First Amendment made two key changes. First, it introduced the qualification reasonable to the restrictions that Article 19(2) imposed. In a 2015 paper, legal scholar Gautam Bhatia placed this term in context and traced its origins to debates in the Constituent Assembly. The insertion of the term reasonable, he argued, keeps the door open for the courts to step in and examine the legitimacy of the restrictions imposed by Parliament. Second, the amendment introduced into the Constitution the specific terms public order and incitement to an offence. This set of new, narrower terms in the provision was necessitated by two Supreme Court rulings in 1950 that went against the state's power to curb free speech. What were these two verdicts passed by the Supreme Court? Both these verdicts involved the press. Bhushan versus State of Delhi and Romesh Thapar versus State of Madras. It was the verdicts in these cases that essentially promoted the First Amendment. Now, talking about the Romesh Thapar case, in 1949, the Madras government, Tamil Nadu had not been created then, had banned Crossroads, a left-leaning magazine, for its criticism of the government's foreign policy. This led to the first significant free speech ruling by the Supreme Court in Romesh Thapar versus State of Madras. The petitioner had challenged Section 9(1)(a) of the Madras Maintenance of Public Order Act 1949 as unconstitutional. This provision authorized the government to impose restrictions for the wider purpose of securing public safety or the maintenance of public order. The court had to define the terms public safety and public order and examine if they fell within the scope of the restrictions allowed in Article 19(2). The government argued that the words undermining the security of the state in Article 19(2) could be equated with public safety and maintenance of public order. In its majority opinion in the case, the court disagreed with the government and struck down the provision as unconstitutional. The court found a vast difference in degrees between the two provisions. Justice Fazal Ali dissented from the majority view and said that disrupting public order is a means to undermine the security of the state. Now, finally, we talk about the Bhushan case. In 1950, the Chief Commissioner of Delhi issued a pre-censorship order on the RSS mouthpiece organizer, which too was critical of the government. Its publisher Bhushan challenged Section 7(1)(c) of the East Punjab Public Safety Act, which allowed pre-publication scrutiny of material prejudicial to public safety or the maintenance of public order. That's it for this podcast. Thank you so much for listening. to join KSG India courses and to crack the IELTS exam, visit ksgindia.com. You can also get a PDF of this podcast on ksgindia.com.